Hi, this is Attorney Haji, and welcome to Attorney Tips, the law in the market. Our topic for today's discussion is Module 3 of Criminal Procedure, the sufficiency of a complaint or the information. So, sa mga estudyante ko sa PCC, this is the meat of the discussion for your midterm examination. So, sit back, relax, and enjoy as we discuss the topic. So, let's go. Okay. First and foremost, what is a complaint? A complaint is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer or other public officer charged with the enforcement of the law violated. This is stated in Section 3 of the Rules in Criminal Procedure, Rule 110. So, eto guys, sworn written statement charging a person. Ang gumagawa nito kadalasan dito sa local level is the police station, the investigators in the police station. So, a complaint is also filed by private practitioners na doon dumidiretso, and complainants are availing themselves of the services of a lawyer, a private lawyer, or the PAO. Okay? So, this is subscribed by the offended party. Sinumpaan ng biktima. Any peace officer, kung walang private complainant, or other public officer charged with the enforcement of the law. Kadalasan, ito yung mga barangay captain or barangay kagawad. Okay? So, that is complaint. Now, how about an information? What is an information? An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. An information is written by a prosecutor where the crime was committed. The jurisdiction is with the office of the city prosecutor. Me as a prosecutor assigned in Pasig City, I usually do this. Make an information of a particular case. Okay? So that's it. Clear? Let's go. Now, kung mapapansin nyo sa isang complaint or information, sa isang kaso, it starts with people of the Philippines versus Juan de la Cruz. Okay? Bakit people of the Philippines? Because criminal actions must be commenced in the name of the people because a crime is an outrage against the peace and security of the people at large. So must its vindication be in the name of the people. Kasi nga, this is usually a crime against the public. Okay? So the peace and security of the public is destroyed or is disturbed. So it must be with the people of the Philippines versus Juan de la Cruz. And the private complainants in this case are only witnesses of the prosecution. Okay? Clear. Now, what is the form of a valid complaint or information? Siyempre, it should be in writing. It's the name of the people of the Philippines and against all persons responsible for the offense involved. So, dapat kasama lahat ng kinakasuhan sa isang particular case. Okay? Now, nakalagay dito, when is a complaint or information sufficient? So, these are the elements to make the information or complaint complete. Okay? Siyempre, the name of the accused, the designation of the offense given by the statute, the acts or omissions complained of as constituting the offense, the name of the offended party, yung nagrereklamo, and the approximate date of the commission of the offense, and the place where the offense was committed. Take note, guys, that, as discussed before, that venue is jurisdictional. So, kailangan, dito sa place where the offense was committed, kailangan particularly describe siya. Okay? Now, what is the rule in determining the name of the accused? So Section 7 of Rule 10 establishes the following rules. The complaint or information must state the name and surname of the accused or any appellation or alias or nickname. Boy Bawang, Juan de la Cruz alias Boy Bawang, by which he has been or is known. He is locally known. Number 2, if his name cannot be ascertained, he must be described under a fictitious name. A description of the accused under a fictitious name must be accompanied by a statement that his true name is unknown. Usually, pag hindi nahuli yung suspect or hindi identified personally, nakita lang, hindi nakita yung mukha, hindi alam yung pangalan, we usually put John Doe, Peter Doe, John Peter Ben Doe. Okay? So, it's the John Does. Sila yun. Sila yung pag hindi alam ang identity, the true identity of the accused. Number 3, if later his true name is disclosed by him or becomes known in the same manner, the true name shall be inserted in the complaint. This is usually done pag nahuli na or na-identified na and na-pinpoint siya ng mga witnesses. So, the complaint here is amended. Okay? The information here is the amended and it is with the discretion of the court. Okay. Next question. Is the mistake in the name of the accused equivalent to a mistake in the identity? No. A mistake in the name of the accused is not equivalent and does not necessarily amount to a mistake in the identity of the accused, especially when the sufficient evidence is adduced to show that the accused was pointed to as one of the perpetrators of the crime. In short, once the accused was identified, physically pinpointed by the private complainant or any of the witnesses na siya yung perpetrator of the crime, kahit mali yung pangalan niya, sigurado kulong pa rin siya. Okay? It's not necessary na yung name is the actual name of the accused. Okay? As long as his identity as the perpetrator of the crime is valid, is established. Okay? What is the rule regarding the name of the offended party? So, kailangan yung nagrereklamo, totoong pangalan din. The complaint or information must state the name and surname of the persons against whom or against whose property the offense was committed, or any appellation or nickname by which such person has been known. Okay? Now, usually in minors, na kailangan i-protect ang identity, usually, we use alias. Alias Maria. We hide the identity of the private complainant for safety reasons. Okay? Pero kung wala naman, walang safety issues, we usually put the name, the actual name of the private complainant. Okay? Now, if the offended party is a juridical person, sino to? A juridical person is usually a corporation or an association like Jollibee Corporation versus the private complainant in a theft case. Ninakawan si Jollibee. Jollibee Corporation represented by the manager, Mr. Juan de la Cruz. Okay? So, it is already sufficient. Ilagay mo siya Jollibee Corporation. If the offended party is a juridical person, it is sufficient to state its name or any name or designation by which it's known or may be identified without need of averring that it is a juridical person. It is sufficient. Jollibee Corporation. Okay? Next. The next, what's this? The next element is the designation of the offense. Usually, the investigators do this, or the prosecutors handling the case do this. What's the rule? First, the designation of the offense requires as a rule that the name given to the offense by statute must be stated in the complaint or information. If the statute gives no designation to the offense, the reference must be instead be made to the section or subsection punishing it. Example, um, violation of the drug law. Okay. Usually, I put there violation of RA 9165, the anti-drug law. And the particular provision violated. Section 5 refers to the illegal sale of dangerous drugs. I put there Section 5, illegal sale. Ano pa? RA 91, violation of RA 9165, Section 11, illegal possession of dangerous drugs. So, if the statute gives no designation to the offense, kasi the violation of the drug law, the anti-drug law, is very broad. So, you put the specific section. So, sa RA 9165, the drug law, there are two main topics. The Section 5, the illegal sale, and Section 11, the illegal possession of dangerous drugs. Okay? So, I hope it's clear. Next. And ito pa. It should be included in the complete designation of the offense is an aberment of the acts or omissions constituting the offense. Siyempre, sa drug law, ilalagay mo doon. Ang paano ba na-commit ang sale? Nagbenta sa isang pusher buyer na police operative. Or nung nahuli siya, ilalagay mo doon ilan gramo yung nakuha doon sa akusado. Okay? The next is the present rule also provides for mandatory requirement. The complaint or information must specify the qualifying aggravating circumstances of the offense. Usually, ano ba? Sa murder, kailangan with treachery, with the aid of armed men. Go back to your criminal law book 2. No. It's book 1. Aggravating circumstances and qualifying circumstances. In murder, you must allege the qualifying circumstances of treachery. Ano pa ba? Usually, the very famous is treachery, alevusia, with evident premeditation. Ilalagay mo siya doon. How about theft? To make it qualified, it must be done by a domestic with abuse of confidence. Ilalagay mo siya doon with abuse of confidence to make it qualified. Without which, it's simple theft or simple homicide only. Okay? So, ito pa. Must the qualifying aggravating circumstance be stated? Yes. That is required under Section 8 of the Rule 110, that the complaint or information in designating the offense shall specify the qualifying and aggravating circumstances. A statement of the qualifying and aggravating circumstances is considered as part of the cause of accusation. It must be stated in an ordinary and concise language. This allegation also must be proven and must be alleged. Otherwise, they should not be considered. So that's clear. Okay. What is the purpose of designating the cause of the accusation? First is to enable the court to pronounce proper judgment, to furnish the accused with such a description of the charge as to enable him to make a defense, and as a protection against further prosecution in the same case. Okay, sa paggawa ng complaint, ilalagay mo na lahat. Paano ba talaga nangyari yung krimen? Paano mo ipapashoot yung nangyari dun sa kaso? Dun as specified by the law. Okay? So, what is the rule? Siyempre, nalagay mo the offense being charged, the acts or omissions complained of, paano ba siya pinatay? Okay, in a case for murder. Paano ba siya pinatay? Binaril ba siya? Sinaksak ba siya? Paano siya sinaksak? Sinaksak siya pataas? Sinaksak siya pababa? Saan siya binaril? Saan siya sinaksak? So you should, in the complaint, you should specify in particularly how the crime was committed. And also, the qualifying and aggravating circumstances. Whether it's done by treachery, binaril sa likod, sinaksak sa likod, or pinagplanuhan with evident premeditation. Okay? Now, ano pa ba? It's done during nighttime, with the aid of armed men, with the aid of a band. Okay? So, these are the samples of qualifying and aggravating circumstances. So, you need to put these allegations in the complaint, and syempre sa information, bahala na yung fiscal dyan. But for you guys, what I recommend is that you must study well what will you put in your complaint. Okay? Otherwise, i-dismiss ko yan. Next. Duplicity of offenses exception. Paano ba siya? What does duplicity of offenses mean? In an information or complaint means the joinder of two or more separate and distinct or different offenses in one the same information or complaint. Take note, the rule is one complaint, one case. Okay? So, pag homicide lang, patayan lang. Pag theft, theft lang. Except if it is a complex crime or special complex crime. Rape with homicide. Hindi siya rape with murder. A rape with homicide is a special complex crime which you have studied in your criminal law book 2. Continuous crimes, kidnapping with homicide, kidnapping with rape. Okay? Complex crimes, paano ba siya? Estafa through falsification of commercial documents. Paano siya nangyari? Ini-explain mo, okay? Qualified theft, paano ba siya yung theft? Robbery with homicide. Robbery with damage to property. Pwede ba yan? Okay? So, if it's a complex crime, special complex crime, pwede siya. Pwede siyang sa isang complaint or information specified na ganon. Alright? Walang violation doon. Now, what if there is a violation? Should there be duplicity of offense in the information unless a single punishment or various offenses is prescribed? The accused must move for the quashal of the same before arraignment. Otherwise, pag hindi ang akusado ay hindi nag-move for the quashal of the information, pwede siyang makasuhan, pwede siyang magkaroon ng judgment against sa kanya as many cases as described in the information. Pag wala siyang nagreklamo. Okay? Next. Amendment or substitution of the complaint or information. Guys, importante to. Pag merong pagkakamali sa complaint or sa information. So, ano ba yung pwedeng i-amend? Only valid information may be amended. An information filed before the effectivity of the law punishing the offense may not be amended after the law. Okay. Iba to. Yung amendment. There are two kinds of amendment. There is the formal amendment and that there is a substantial amendment. What is a formal amendment? It's an amendment which it neither affects nor alters the nature of the offense charge, or the charge does not deprive the accused of the fair opportunity to present his defense, and it does not involve the change in the basic theory of the prosecution. Okay. Example ito, mali yung pangalan. Mali yung spelling ng pangalan. Okay? Walang pagbabago sa, hindi na ilagay yung date. Kailangan mali yung year. Imbis 2021, nilagay 2020. Copy-paste. Victims ng copy-paste. So before basahan ka ng information, pag nakita yun ng piskal, pwede siya mag-make ng, with the discretion of the court, pwede siya mag-move for the amendment of the complaint, of the information. Okay? When is there an amendment in substance? There is amendment in substance where it covers facts, matters involving the recital of facts, constituting the offense, charge, and the determining the jurisdiction of the court. So, pag substance na, merong change, major change, na kailangan ipagpaalam sa court. Like, a change from homicide to murder. Okay? Or from reckless imprudence resulting to serious physical injuries, namatay bigla. So, kailangan it's reckless imprudence resulting to homicide. So, kailangan mo siyang i-amend. Substantial amendment. So, you need to file a motion with the court and it must be with the discretion of the court. Otherwise, it is unconstitutional. Right? Next. So, kailan ba siya ginagawa? It is made before the plea. It is made before the arraignment. And it should be with leave of court. Okay? Pag walang leave of court, walang permission ng korte, eh hindi mo po magagawa. Okay? So, yan. Ito na, discuss na natin to. Can the prosecutor amend the information which changes the nature of the crime after arraignment? Hindi na pwede. Unless supervening event, the doctrine of supervening event, namatay, as discussed a while ago, reckless imprudence resulting to serious physical injuries. After 2 months, after a month, if you can prove that the cause, the proximate cause is the act of the injury, eh namatay, o di i-amend mo yung information, gawin mong reckless imprudence resulting to homicide. Okay? So, but still, it should be with the discretion of court. Otherwise, madi-dismiss yung kaso. Next. Okay. Venue of criminal actions. Take note, guys. Venue is jurisdictional. Where should a criminal action be instituted? We discussed this on the topic of jurisdiction. Review lang to. Subject to existing laws, criminal action shall be instituted and tried in the court or of the municipality or territory where the offense was committed or any of its essential ingredients occurred. Except, as discussed in Criminal Law Book 2, Book 1, an offense was committed on a railroad, train, or in an aircraft. So, English law and French law, you know this already. Pag nangyari sa barko, okay, and felonies under Article 2 of the Revised Penal Code, ito yun guys, alam nyo na to. So, dito, venue of the crime, importante dito. Ano yung importante dito? It should be instituted and tried in the court of the municipality or territory where the offense was committed. Paano ba ito nangyayari, guys? The case, the incident happened in Pasay City. Who has jurisdiction over the case of homicide in Pasay City? It is with the regional trial court. Why? Because the penalty for homicide is more than 6 years. So more than 6 years, it's with the Regional Trial Court of Pasig City, which is located in Dumangas. Pero sa Pasig City tayo nag-hearing pa din. So it is with the Regional Trial Court having jurisdiction over Pasig City. Now, what if the homicide happened in San Enrique, Iloilo, outside of Pasig City? Where do you file a case? Where is the venue of the case? The venue of the case is with the Regional Trial Court having jurisdiction over the province of Iloilo. Okay? Provincial case na siya. Okay? Hindi na siya covered ng Office of the City Prosecutor of Pasig City. Okay? So, that's clear. We proceed. Okay. When is intervention of offended party allowed? What is the intervention? Usually, pag yung private complainant nag-hire ng services of a private prosecutor, may kinalaman ito dito sa award of damages. Only the public prosecutor has absolute control of the trial of a criminal case, except if it concerns damages, the amount of damages, where the civil action for the recovery of civil liability is instituted in the criminal action. Okay? Next. Exceptions. So, kailangan mo siyang mag-file ng separate case or sa criminal case, diretso na ang pag-file ng civil liability. Usually, it concerns about actual damages, moral damages. Depende sa mga cases na ganito. So, that's it for Module 3. Hope you enjoyed the presentation and see you on Module 4. So once again, this is Attorney Haji and you are on Attorney Tips.